we're going to start with number 162, People versus Caldavado. Counsel?
May it please the Court, I request 2 minutes rebuttal.
2 minutes, you have it. Go ahead.
Good afternoon, Your Honors. My name is Mark Baker, and I'm here on behalf of Alma Caldavado. Your Honors, in a 2009 trial, which was conducted 11 years after a fierce debate began in the medical community,
Tell us, counsel, what was the mistake that defense counsel made? Is it totally impossible to represent the defendant without calling experts on this particular issue?
Absolutely.
Why?
We're talking about an area of medicine that for 25 years was predicated upon a triad set of findings of retinal hemorrhage, cerebral edema, subdural hematoma.
When did it start to change?
1998. When
1998, the scientific view of this changed, and at the time that the defense attorney was representing your client, what was going through his head about the scientific evidence, or what should have been going into
What should have been going through his head was what he was told by Dr. David Klein, who he had consulted, who told him that, in fact, there was chronic blood that could have caused these seizures and could have caused...
More than once in trials, you retain an expert that you don't intend to put on the stand for a host of reasons.
That's correct.
But you use their knowledge and to cross-examine the prosecution's, in this case it would be a prosecution witness. Would that be a reasonable tactic or strategy in some cases?
Not in a case such as this. We're talking about a very intense debate that commenced with the Boston nanny trial, Louise Woodward, in 1998. Got a lot of publicity. We're talking about a situation where, for many reasons, a whole body of medical literature had started to be published, and certainly for 11 years, because the triad findings were found to be owing to many, many causes. For instance,
Counsel, with respect to those findings and articles, the articles that different counsel came up with, the ones from Dr. Olczynski, 2004 and 2008, those were, are you saying those came after the debate and so they weren't available at the time of trial, or what are you saying about that?
I am saying that if the defense attorney spent 20 seconds on the Internet in 2009, he would have seen that the testimony being offered by the people in this case had become subject to challenge in many cases. The Edmonds case, the Louise case.
But was the only way to meet that challenge was to have an expert on his part?
The only way, Judge.
How does he get around the problem of Dr. Chutorian, if I'm saying the name correctly? Doesn't that create a problem? You have an expert. The way I read his proof, the expert, it's not helpful to you. And then any next expert who reviews his report is going to potentially make it admissible and be very damaging for your client.
Well, that may be true. That was available. But that wasn't something that
you see the trial problem, though, I'm bringing up.
Yes, I do.
Yeah, so.
But the fact of the matter is, Dr. Klein, who he did consult with,
Right.
put in his report that there was indeed chronic blood in this analysis.
The original report of Dr. Klein I didn't think was quite as definitive or helpful for the defendant. It was better than Dr. Chutorian's. But if Dr. Klein, of course, had testified, that Dr. Chutorian's report would have ended up coming in.
Dr. Klein was stating that once subdural hematomas are present, there may be spontaneous episodes of fresh bleeding into these areas produced by little or no available new trauma. Now, if I'm a defense attorney and I'm told that, and then I hear all these witnesses, 12 of them, one after another, saying, no, that's not what happened here.
Right,
this was
but
diluted.
You're saying he should have used is it Dr. Usicki's theory of BESS, the BESS syndrome? Is that Dr. Usicki?
That's benign enlargement of the subdural space.
That he should have been aware of that and should have used that theory to counter them. Isn't that correct?
Absolutely.
So has there ever been a Frye hearing that's confirmed that this evidence would be admissible, or it's generally accepted in New York?
The district attorney suggests there was no Fry hearing. This court has held repeatedly. There's no Fry hearing required when an expert gets up and gives his own personal opinions about his experiences in this particular area of medicine.
So your argument is no Fry hearing would be necessary?
None at all.
There's no controversy in the medical community that way? This is generally accepted, this theory?
No, that's the whole debate. That's the fact.
That's my problem.
Look what the-
I'm
look for-
wondering how you get around the requirement for some kind of a Fry hearing, at least a request for one.
Because you call a Dr. Yushinsky, you call a Dr. Scheller, you ask them, what have you seen? Oh, I've read all the reports, I've looked at all the images, I see no problem in terms of what happened here. The fact is, this child had benign external hydrocephalus, an enlarged head, which means there's a lot of fluid, and that in turn could cause the rebleed, which in turn cause the seizures, which in turn cause the hypoxic ischemic injuries that my learned adversary is going to be telling you about.
What about the point, I think that your adversary makes in his brief that, or it may not be in his brief, but the argument is that he could only afford maybe one expert, and there were 12 experts testifying on behalf of the people, and so it may not have made that much of a difference to have one expert come in.
That's an excellent question. I refer you to People versus Ackley, decided by the Michigan Supreme Court in June 29th of this year. I sent it up to the court when I learned about it. May I quote? The prosecution's voluminous expert testimony made the need for an effective response by, they had 5 witnesses in that trial, made the need for an effective response by defense counsel particularly apparent and strong, and it rendered counsel's failure to offer expert testimony particularly glaring and harmful to the defendant. Because of counsel's omissions and the resulting absence of suitable expert assistance, the prosecution's expert testimony appeared uncontested and overwhelming. We had 12 here, lockstep. And then you have Dr. Alexander, the paid consultant from Florida. He gets up and talks about the triad, which my good friend Mr. Castellano is going to call the constellation, but that's just nomenclature. It's the triad of symptoms. And he's talking about, we have the subdural hematoma, we have the edema, the swelling, or else it can also be concepted as the encephalopathy, which is the hypoxic ischemic injuries that result, the global injuries, and we had the retinal hemorrhaging. And what do you have as a result of that? He showed an anatomical doll shaking like this.
What's the rule you're looking for here? I mean, does this mean that all shaken baby convictions after 1998 have to be set aside? Does it mean that every time someone doesn't call an expert with respect to weapons and things like that, where you don't call an expert saying that the striations are different or the things like that have to be set aside, all because we didn't have an expert?
Yes. I am saying in a case such as this, where
That's a pretty big...
I think I'm backed by the medical research. The fact of the matter, let me put it
You're
this
saying there can be no conviction in the state of New York after 1998 where there isn't an expert?
I am saying that in a case such as this, where the prosecution relies upon a triad which has been come to be subject to so much dissent by so many different experienced medical practitioners, that it is ineffective assistance of counsel per se not to allow the jury to be told there's another side to the story, and you haven't heard it, because they were absolutely sold, overpoweringly sold, by the fact of this testimony. They had no choice. This was an inquest. This was an inquest. Now, counsel talks about all the cross-examination that had to be done. But the
Well, that's the other part of it, because what you're essentially saying is that all the people's witnesses lied.
No, I'm not saying the people's witnesses lie. I'm saying they are wedded to a doctrine that has come to be disputed, because each of these causes, for instance, the acute hematoma, that has been demonstrated to be owing, in the articles that we've submitted to you, as has Amicus Innocence Network, to benign external hydrocephalus, the very fact of what happened in this case. And I'll tell you something, Judge Pickett. I know this personally. My grandson was born with this, and my daughter was given a letter by her pediatrician to hold, which says, basically, if she had to go to the emergency room with a head injury, that this child has benign external hydrocephalus, and so you have to look for other than non-accidental causes. This is well studied and well-supported.
I'd like to ask, too, something that Judge Piggott just mentioned. You said only in situations like this. Are you saying that this rule would only apply in medical cases like this? What about the other cases that there might be some dispute about whether there's a syndrome or some other kind of theory that has been generally accepted prior to some new theory coming up? Are we now saying that you have to have an expert in every one of those cases?
How can an attorney represent somebody?
This sounds like a yes.
Well, it is a yes. I'm sorry, I should have said that first. I usually do. Yes. How can an attorney represent someone who is said to have shaken a baby so violently that these Trian symptoms appeared and they are indicative of violent trauma, not educate a jury that there is a whole body of thought that has come to the fore in the last 11 years that takes strenuous issue with this? That's reasonable doubt, perhaps as a matter of law.
Is he not educating a jury, or is he not educating himself?
He's not educating himself because he's not educating the jury because he didn't educate himself. And the record will.
His duty is, to the extent you see it, is in addition to obviously trying to educate the jury, to conduct some kind of investigation as to all this stuff that's out there. I mean, is that his responsibility?
He didn't do that.
As an attorney?
How do we know he didn't do it?
Because
He hasn't offered anything about what he did or didn't do in preparation for this trial.
the motion papers that I drafted demonstrate that when I called him up to ask him, and I sent him a letter asking him to explain,
But
there was no response.
He refused to, well, that
Okay?
doesn't.
So order an evidentiary
He
hearing.
didn't want to give him, well, okay, so that's my question.
Let me
Would-
put
would
him on
that
the
be
stand. I got a
appropriate?
lot of questions for him.
Would that be appropriate?
That would be appropriate. Why didn't you? In a case such as this, there was no excuse not to.
Well,
And he
maybe
won't
there
have it.
was. Maybe he thought, maybe it was not the best choice. It certainly
Judge Stein,
wasn't that.
he has an expert who wrote him a letter telling him, giving him the defense. And when it comes to cross-examination, he doesn't even go to the other issue that Dr. Yashinsky talks about. This child had no neck injuries. Now, if he would have done his homework and realized that's one of the reasons why the triad has come to subject to so much question, there's no neck injuries. Now, the one witness who discussed it for the people, said that only happens in lethal cases. Well, that's not true. That happens in cases just like this.
So what type of hearing are you suggesting? Because you've asked for a hearing on actual innocence, but it sounds like in response to Judge Stein's question, that would be just a regular 440.
That's correct.
So you're saying a regular 440?
On ineffective assistance of counsel, that's what this Court has always said. Why do I not bring it up on direct appeal? Because we don't have enough of a record to make an appropriate disposition. If that's your remedy, that's fine. I obviously think if you accept the actual innocence proposition that we propound along with the amici, that you can make a determination in and of itself based upon my experts who are unassailed, who say, and they've looked at all this and say there was BEH that caused this acute trauma and there was no neck injury, and therefore this child could not have been shaken. I think you have enough to throw out the indictment, but if Judge Stein's position is the one that holds force, and we have to hear what the lawyer says, then evidentiary hearing is
Okay,
appropriate
counsel,
remedy.
let's hear from your adversary, and you'll have your rebuttal.
Thank you very much.
Thanks, counsel.
May it please the Court. My name is John Castellano for the Office of Richard A. Brown. Your Honors, defense counsel in this case was not required to consult with a third and fourth medical expert after he had already
Counsel,
consulted.
that's not the issue. Should he have called an expert to the stand to give proper representation to defend it?
He was not required to do that. Now, there's
How
different.
could he not be required in this kind of case where you bring in 12 experts? What could be the rationale of why any kind of halfway effective counsel would not provide an expert on this at a time, as your adversary says, where the science of this is very much, up in the air?
First of all, 11 of the physicians were treating physicians, so they were being called in any event. But what he says and what he tells the family, there are two reasons. Number one, what he tells.
And do we know, apropos Judge Stein's question, Do we know what his reason is?
Well, what we do, in fact, in the
Go ahead.
submission, in fact, of the submission by defense counsel of the sister's affidavit, she says what the attorney told her, which is this: I can never match them expert for expert, 12 to 1, 12 to 2, 12 to 3. I can't
But
do it.
0 to 12, does that mean?
But what he says is, what I'm going to do is this: turn the experts on themselves. They have 12. The more experts they call, the more contradictions I get, the more concessions I get, the more reasonable
Is
doubt
that
that
what
I
you would
make.
do in this case?
Absolutely, Your Honor.
As a defense attorney, you would have said to yourself, oh, I'm not going to call an expert, I'm going to turn these guys against themselves?
Absolutely. This was a very smart defense. It was also smart for another reason, because
Why would that exclude calling an expert, too? Why is that mutually exclusive?
it's not mutually exclusive, but this is the advantage that it has. The advantage is that he does not have to call someone like Dr. Klein, because Dr. Klein, in his letter, in addition to the quoted portion, I think, from before, he says that the standard diagnosis in this situation is shaken baby syndrome. And any doctor is going to have to essentially testify to that, or testify to the fact that their views are distinct minority views, really outlier views, although they may just call them distinct minority views. And that bears the potential for reconfirming the prosecution case. Now, he can put on his defense.
But how could that be worse than having nobody say it at all?
I'm sorry.
How could that be worse than having nobody say it at all? In other words, if you're the juror, you know, you're looking for, is there any doubt, is there any reasonable doubt? Maybe in the end you'll find that, yes, the majority view is the one that I think is more persuasive. But if you don't even present the minority view.
But, well, I guess there are multiple things going on. One is there an expert in support of the rebleed defense? And that's what Dr. Klein gives to defense counsel based on a well-established medical phenomenon, and he pursues that. He pursues it doggedly. He pursues it at every turn during the trial, during every cross-examination, and he sums up on it by saying this. He turns the numbers game around. What he says is, instead of 12 experts, first he says, if this is so open and shut, how come they need 12 experts to tell you so? I don't need 12 experts. I need one reasonable doubt. And then he blows up the MRI reports and the CAT scans and the testimony, the actual testimony with their concessions by the witnesses, and he even makes a chart of contradictions of the people's witnesses. The chart doesn't eventually, he doesn't get to use it, the judge doesn't let him use it, but he has all of this, and he literally points to the reasonable doubt. Here it is, here it is, here it is. And the advantage of it is he doesn't have to put a witness on the stand who says, my view is a minority view. Yes, the standard diagnosis in this situation is shaken baby syndrome. And all of the witnesses that we're talking about would suffer from that
You don't
that
think
problem.
the jury wondered why he didn't have an expert to come and present this view?
Well, he addresses that in the summation, and he specifically says, if this is so open and shut, how come they need 12 experts? They tripped all over themselves. Let defense counsel,
But if he had had one expert, and he could have made that argument even stronger. They have 12. I only need one. All you have to do is believe my one.
But the problem is that one is now confirming the prosecution case, or potentially so. It bears a risk. And here's the thing.
If that one were Dr. Utensky, who's the expert on the BSESS, then he wouldn't be conceding anything. His view is the majority view for that theory.
No, it's not the majority
Not
view
the
at all,
minority
actually,
view.
for that theory. In fact, here's the problem with Dr. Udzinski.
No, what you mean, it's not the majority view in the scientific community.
Correct.
He's the main proponent of that point of view, but it's not the majority view in the scientific community, which, yeah, okay.
Right, absolutely. He's not the majority view. And here's the problem with the best defense when it comes down to, as far as counsel, from the point of view of counsel trying to put on such a defense. It is medically unsupported. The first question on cross-examination is this: Doctor, has there ever been a case of benign external hydrocephalus that has produced these injuries, the brain damage, the extent of brain damage that this child had? And the answer to that question is no. There has never been such a case. So that bears a potential for hugely backfiring, and instead he has this very well thought out, very well planned defense, which he sums up nicely for the jury by saying this. They're trying to...
still a need at least for a hearing, apropos of Judge Stein's questions before?
No, because on the trial record and the submissions, this issue can be resolved. And that's the standard that this Court set forth in People v. Satterfield. Can an objectively reasonable attorney, specifically on ineffective assistance of counsel in a 440-10 motion, the standards in Satterfield, and it says, viewed objectively, could a reasonably competent attorney have a trial strategy that would produce this result? And that is absolutely the case here. A reasonable, objective attorney could have such a strategy. And this is the strategy. And the other thing that's important to remember is that I don't have to show that it's the best strategy. I don't even have to show that it's a good strategy.
It can't be an absurd strategy, can it?
No. It has to be a reasonable strategy.
Yeah,
but
viscerally, it would seem to be an absurd strategy.
not at all, Your
Viscerally.
Honor.
I know you're trying to explain it, but it really seems odd.
Not at all, Your Honor. First of all, as I say, you've
Well,
got
to you, it doesn't seem odd.
You've got the numbers game that he's worried about. He turns it around. He presents the defense as a reasonable doubt defense. It's like this, if I may. It's as if a defense attorney has a choice between attacking the reliability of an identification and putting on an alibi witness. I can put on an alibi witness, but the alibi witness could backfire. That's the problem that I'm having. If the alibi witness backfires, they're not even listening to the rest of my defense, because if the alibi witness
I gather your view is what it is because you don't believe that there is a serious debate scientifically about this issue. I mean, I could understand that. If you go from the premise that there's no real debate here, this is all made up scientific mumbo jumbo, and I have no real case, so therefore I'm not going to put an expert. But if hypothetically you believed that there was a serious scientific dispute, as your adversary says, that in recent years there had been a whole school of thought that comes into play different than the old view of shaken baby syndrome in this particular context. If that were the case, would you still say that not putting one expert on was a brilliant strategy or an okay strategy?
Well, it depends on the degree to which the science has been overturned. If you have a case
I'm giving you my hypothetical that in recent years, serious doubt has been put about the old way that we determine what were the signs of shaken baby syndrome. If you accepted that there was a very serious school of thought that had put into at least serious question the old way of looking at that, would you still say, I'm not going to put an expert on, is an acceptable strategy?
It is an acceptable strategy.
Even in that hypothetical?
Even in that hypothetical, because the serious doubts isn't alone enough to overcome what would be potentially a confirmation of the people's case. But it doesn't matter. What we're talking about here, and I encourage the Court to look at the statement of the American Academy of Pediatrics in 2015, which goes through all of this, summarizes all of this complicated medical literature, and tells us what the state of the medical knowledge is at this time. And it's in no uncertain terms. It says
but I'm asking you a hypothetical. If we don't agree that that's what it says, you still would say this is an acceptable strategy.
It's an acceptable. It's a strategy. Yes. How dangerous is it to put that person on?
Would his strategy have been different if his first expert had helped him? He goes to Tutorian. That doesn't help him, does it?
It doesn't help him at all. No.
What does it do to him? What does it do to the defense's case, Tutorian? He says the people are right, right?
He absolutely says the people are right.
So what if he had found somebody else? He went to Klein, and actually Klein had two reports. The original report actually wasn't that helpful to him. Mm-hmm. And then there was a second report. And then I think where Judge Lippman is referring to. Why aren't you going there then? I don't get it.
Why aren't you going?
Why is it ineffective assistance of counsel to put somebody on at that point?
Why was it necessary to consult another expert at that point?
Yeah.
Because he doesn't have to second guess his own experts.
So you're saying he talked to two experts, that's enough. He saw that he didn't have a winning case that way, so he had to attack their experts?
Well, it's not that he saw that he didn't have a winning case. He had a defense, and he pursued that defense, and he pursued it doggedly and relentlessly during the course of the trial.
If you argue that theory, then he should have put an expert on.
No, absolutely not, Your Honor, because he's what he's doing is creating a reasonable doubt defense, just like a defense attorney in an ID case attacks the reliability of the identification without putting on the alibi witness. You could say in hindsight, well, he should have put that alibi witness on because the reliability, the reasonable doubt that he was trying to inject into the identification wasn't good enough, so you had to put that alibi witness on, except that he made a strategic choice at the time.
But
Yes.
through that choice, how are the people's experts going to say anything better or worse than what his own expert would say? Doesn't that get you, again, at equal poise? He's got an expert that says there are issues, that this is potentially not the reason for the baby's death. He's going to cross-examine all of the people's experts, and then the people are going to cross-examine his expert, and again, the jury will make its decision. So
Right.
how is he, I guess the question, how is he put in a worse place by calling that expert?
The worst place is the failed defense. It's like putting on a failed alibi or an alibi for the wrong
This
date.
is what I'm saying. How can that possibly be? All you're saying is that you're going to cross-examine his expert and raise some questions. Well, he's doing that with your experts.
But it's much more than that, because there is no scientific basis for it. It's going to fall so flat that it's going to be the equivalent
Well, then what's his
of
basis
that.
for the cross?
I'm sorry?
What's his basis for the cross?
The basis for the cross is the Rebley defense. It's what Dr. Klein gives him. And here's the difference also. The Rebley defense, as Dr. Klein tells him, is well recognized in the medical profession. So he can work with that, as opposed to a defense where he's got to take on the whole medical establishment. Whatever else you want to say about it, he's got to take on the rest of the medical establishment. He is behind the eight ball from the outset. So he can either do that and take on the whole medical establishment, or he can go with a defense that is well recognized, based on a principle.
We don't know that he did that, though, do we, counsel? Because he did consult Dr. Klein, but we don't know that he consulted any of these other, we don't know what other research he did, because he decided that he didn't need an expert. So we don't know if he could have come up with a better defense than the Rebley defense.
Well, we do know what he did. He did consult two experts. They were two independent experts, two specialists in their field, in the field of shaken baby syndrome, and he was entitled to rely on that. It was reasonable to rely on them.
Maybe she's guilty. I mean, it seems to me that maybe the defense looked at, as I understand it, most of your experts were fact witnesses. They were treating physicians.
Correct.
And they said, I saw this, and this means that, and there's not a lot you can do against fact witnesses who say, I was there, I saw this, this is what my findings were, et cetera. He opened, I think, insinuating that, yeah, she shook the baby, but she shook the baby to see if it was okay or something. I mean, am I incorrect in that?
What his defense really was this, and he sums it up very nicely in the summation. He says, they're trying to pin this on my client for the timing, because she was there when all these symptoms developed. But what we know, he says, is that there was a prior, what he calls a prior brain injury. Not really so much an injury, there was a condition, but he says there's a prior brain injury. And that means that my client is not responsible for it. Let them explain it away. He puts a huge burden practically on the prosecution by saying, let them explain it away. He literally says, they tripped all over each other. Let her explain that. That's a difficult burden in a medically dense case for the prosecution to shoulder. We shoulder it. We shoulder it by witness after witness, but that's not his fault.
Didn't you also put on one treating physician, I think it was Dr. Chan in the emergency room, who saw, he testified that he saw the defendant shake the baby in the emergency room?
Absolutely. Twice, Your Honor. Yeah. Twice, Your Honor. And I think that's important to take into account as well in this picture, because he's doing really a yeoman's job in a very, very difficult case. He's got the shaken baby syndrome diagnosis, 11 treating physicians. He's got his own doctor telling him this is a shaken baby case, classic case of shaken baby syndrome, and then he gives a doctor who gives him a wedge, who says, you know, standard diagnosis is shaken baby syndrome, and by the way, as he says, this is strongly supported by clinical experience, it's well documented in the medical literature, and the babysitter has acknowledged shaking the baby. He doesn't even know about the incident at the hospital, double incident at the hospital. He's got all of that, facing all of that, and he's now got a wedge, though, from Dr. Klein. And he's
Thank you, counsel. Counsel rebuttal.
This one was. First of all, Judge Abdus Salam, that testimony about what happened in the hospital was not supported by the parents who were right next to the gurney.
Yeah, but I get that you're trying to pick this apart, but that's what the defense was trying to do as well.
I understand.
And we can do that all day.
I don't think that's pertinent to the what's before the court right now. What I am telling you is that Mr. Castellano's argument is completely unburdened by all the case law that has developed in the last
Well, yeah, but
years.
I took this note. Yushinsky, one of yours, opined that humans are incapable of inflicting a subdural hematoma on an infant by shaking the infant.
Right, that's his position.
Scheller opined, that's yours, that Fiona's subdural hematoma was activated by her bouncing in a walker or being bumped on the head.
Correct, because of the
Is there a little
BEA.
inconsistency within the two of them? One says you can't do it, and the other one says that's
No,
how it could happen.
they consulted, they read each other's letters, and they felt they were
But
not
isn't that why we get down to tactics? In other words, I'm just wondering why this lawyer was so incompetent when we've got, experts who testified and opined and decisions made. I tend to agree with the people in many cases where rather than risk putting somebody on that's going to sink your client, if they've got some of the biggest mistakes people can make is putting on too many experts or put too many witnesses, because then you just...
Well, then they put on Dr. Alexander, who just blew everybody away with his demonstrations and his saying that this is definitely a shaken baby, and he takes an anatomical
Right.
doll and goes like that. When my experts would have said that just couldn't have happened because there's no neck injury, because the head is bouncing up and down in an undeveloped 7-month-old infant. It could not have happened. That had to be addressed.
But
There wasn't even cross-examination about that. And he's relying upon cross-examination as the valid defense that was supposedly put in here.
I just wonder why, in the next burglary case, they never looked in the living room, and there could have been fingerprints of somebody else in the living room, and they didn't call an expert on fingerprints to say that, fingerprints can be found in other places and the timing is bad. I don't know where we draw the line on what you say is incompetence of counsel and where the,
Judge Piggott, we have a
Tactics,
case
strategy.
where 12 experts, and I think People v. Ackley is really on point in all the measures, all the arguments that I'm making today. We have 12 experts, essentially in lockstep.
12 witnesses.
12 witnesses, but they were
Mostly professional, I
Nine of
agree.
them were experts, and then you have Dr. Alexander. The
But
coup de
fact
grace.
witnesses, you have to admit, right? I mean, they
Well,
were
they
there.
were talking about what their findings were, but the findings were the triad. That's what they based their shaken baby
But they saw it, was my
finding on.
point. I mean,
Yes.
they were there, they were treating this child.
So-
They weren't there saying, I've got to find a way to convict this lady. They were there trying to help this baby.
Well-
And they were doing what they thought.
But not
was-
one of them was cross-examined, if we want to rely upon that, about, isn't it a fact that your assessment of this is subject to great dispute? Isn't it a fact that a benign external hydrocephalus
I wouldn't ask
could
that
result
unless
the
I
same?
was sure they were going to say yes. And I'm not at all sure that these people were going
You
to.
ask them if they've read this,
What
this,
they
this.
would have said is, I was there, I saw this is what I concluded, and it's the truth.
But you had Dr.
How would you-
Arsenio, Jensen, who's basing her testimony on the reports alone.
Okay.
And the fact of the matter is that on all the cases, Ackley says you must respond. The Senkowski case, the Federal Circuit, you must respond.
Counsel, what is the state, from your view today, of the science on this issue?
I'm sorry, Judge?
What is the state of the science today, from your perspective, on this issue, in a nutshell?
That there are many different causes for the triad symptoms, many of them nonviolent, many of them demonstrating that there are lucid periods, that there could be 72 hours between an event and the manifestation of that event, which means that the last person with the child is not the one who's guilty, and there are other aspects of this that you can't have.
That's the old bleed defense, right?
The testimony in this case had to be Alma because she was the last person with the baby.
Right.
And the new science is saying, wait a minute.
Okay.
There's a lucid period here, up to perhaps 72 hours, so maybe the last person is not the one who caused it.
Okay, counsel, thank you both. Appreciate it.
Very much.